Welcome to Heald Law Academy, the place where you can quickly learn how to maximise the value of your businesses and safeguard your commercial and personal interests. I'm joined by David Dees, and we're going to take a look at a sting in the tail that can mean that even after you've successfully sold your business or property, you can be sued by the buyer. David, can you give us a typical scenario that you've met in the past that have led to such consequences for the seller?
Yes, certainly. Take the example of some people who've sold their company. They may have received a large amount of money for it and they may have retired. So there they are at home in their garden enjoying their retirement, and they get a call from the buyers who want to make a claim against them for something that they've discovered afterwards. This is obviously a terrible shock. They will quickly find out what the problem is, and in the example I'm thinking of, they were able to say, we told them about this. I remember the meeting. We were at a meeting and I explained all of these problems to them. But it means nothing if it's not put in the agreement.
So how can people safeguard themselves? Just by having an agreement, is that enough?
Well, in a sale agreement, whether you're selling a property or whether you're selling a business, there are a great number of clauses, and part of the exercise is about setting out formally information that you want to provide to the people buying the business. So they can't turn around later and say, I didn't know about it. Those sorts of agreements always contain a clause that say, if you do not write it in this agreement, we can just ignore it. Because often you have situations where they actually knew about the problem, but they look over the agreement afterwards and say, well, they hadn't set it out formally in the contract.
That's so crafty. It
is crafty, but they're entitled to do it because the contract provides that it's only the things written in the agreement that will be binding on them.
And in terms of detail, how much detail should somebody provide in an agreement? What sort of things should people be writing in a business sale agreement?
You've got to put things in which are going to be materially important to the owners. So think of things that might cost them some money if it goes wrong. The sort of things might be whether there's been a dispute with the customer, whether there's any litigation that the company is suffering, even just complaints, anything that's gone wrong with one of their products. All these sorts of things can cause a lot of problems for a buyer and a lot of cost. And of course, if they say that they didn't know about it, then they're going to come after you to get the money back.
And is there no defence in saying, I did tell them about it at the pub or wherever else you mentioned?
This is exactly the problem, because these sorts of sale agreements invariably have a special clause that provides that unless it's written in the agreement, it doesn't count for anything. So any kind of verbals, if you like, things said in the pub or on the golf course, they can just ignore them. Even if you know that they knew about it, they'll look over the agreement, and if it's not covered, they'll say, we didn't know about it.
That is crafty.
I'm afraid it can be.
And in terms of costs, I mean, what sort of costs are we talking about here? Could somebody sue potentially for a lot of money if they do find something that's not mentioned in the agreement? Yeah,
the key thing for the person who's bought the business is to look at the difference between what they paid and what they got. So if they got £1 million company and the problems cost them £100,000, obviously from their point of view they've only got £900,000 worth of value, so the claim is going to be for the difference, the 100,000. They're very unlikely to sue for the whole value of the company. That would be a disaster. But it's those minor differences in the value that they want to recover so that they get their consideration in full.
And in terms of defences, going back to the one you previously mentioned, the clause, is there anywhere else you can sort of protect yourself other than agreement, or it has to be the agreement? It's really important.
It's got to be the agreement. In company and business sales, there's the opportunity to produce something called a disclosure letter, which does exactly what it suggested, discloses things, and it's integrated with the sale agreement so that somebody can look at this document. All the problems are listed in the disclosure letter, and it's absolutely clear what you've disclosed. And often you can tie to it a large bundle of documentation. You're supposed to highlight areas where there are problems. But with the bundle of documents and the disclosure letter, there's no argument then, because they can't say I didn't know about it, because you can point to the disclosure letter. Absolutely clear.
And am I right in thinking this is just for the business in itself? You mentioned like litigation, problems that they might have with external companies and things. What about the actual property, the building? What if there's a problem with that?
It's the same with properties, of course. You may be selling a property, of course, without selling a business. Just a sale of this building, for example. It's exactly the same issue. There, it's a little bit more formulaic in property sales, there are set pre-contract inquiries that you complete.
And you have a survey and things
Well,
like
you
that
have a
as well.
survey, but you're disclosing specific replies to specific questions, and you're able to refer to those replies in the contract.
And how easy is it to initiate one of these contracts? Pretty simple?
Well, I guess you could go to the internet and find something, but it might end up being gobbledygook. Obviously, if there's money at stake, you better get professional advice, that's obvious.
Thanks so much, David, for clarifying those issues. We hope you enjoyed today's discussion, and if any of the issues mentioned are affecting your business right now, then simply call David on the number below, and remember to subscribe to all of our videos, and we'll also send you news of seminars and other events where Heald Law Academy will be presenting. Bye for now.